The key to being successful in employment litigation is that you need to win the little skirmishes long before you get to a trial. And really that starts first with how you draft the lawsuit. We spend probably more time drafting our lawsuits than any other firm in town. And that's because we start first with the realization that behind our cases is a person. It's a husband, it's a wife, it's a son, it's a daughter, sister, or brother. And we want to tell the story of the person in the lawsuit. The other thing that guides how we draft our lawsuits are that this is going to be the very first thing that the judge is going to read. And it's critical that the judge pay attention to our case and say, you know what, this one is different than the 10 other employment litigation cases that were filed this month. Our firm's strategy from the moment that the complaint is filed and through the discovery process is to get through this summary judgment hurdle. And basically, these companies are going to be asking the judge to dismiss the lawsuit because, and essentially arguing that there aren't significant issues of fact that are in dispute and that they're going to win on the law. And so it's not necessary to have a jury trial, that the judge should just dismiss it. And many employment cases end up getting dismissed at that summary judgment stage.
With the summary judgment being kind of the be-all, end-all for the defendant, we realize that. So we're going to look under every rock, just do the best investigation we can to find out what happened. And, we use interrogatories and discovery, and we use it aggressively to get to the bottom of what happened. From start to finish. And if we don't get what we want, if they've withheld something, we'll ask again. And if they don't give it to us, then we'll ask the court to make them do it. And we're aggressive during that, and we need to be.
So Ronald Reagan had a saying with respect to the Russians, which was trust but verify. In an employment litigation case, I think it's better to say distrust everything. It's just time and time again we've found that employers will try to hide the ball once they're sued on an employment decision. So we need to probe every single contention that they've made because they're probably hiding something. And the other thing that's critical is to use the court. So when a defendant, for example, isn't giving us the documents that we've requested or subpoenaed, well, we need to file a motion to compel with the judge and ask the judge to force them to turn over the documents that we're asking for, because there's probably a reason why they're not turning over the documents voluntarily. Now, once we've accumulated the documents that we feel like help prove our case, we go to the deposition stage, and that's the fun part, really, which is when we're using the documents that we've found to maneuver and push the management witnesses where we need to push them or lead them in order to be successful. And it's just amazing what you can do when you have emails from 2 years ago and you're presenting those to a decision maker justifying a termination today. Now, a common gripe from the defense attorneys that we're up against is how many depositions we take. Part of our methodology of looking under every rock is deposing every possible witness that could have information that's helpful to our case.
One of the reasons we do that is because these people have information, and we hear other attorneys say, well, why don't you just talk to them, just interview them, get a statement. Well, people are far more honest when they're under oath, and we just know that to be true. And you would be amazed some of the stuff we have found out from people who the company said, you don't need to depose them, they don't know anything. Well, they sometimes end up breaking the case wide open. And another reason why you don't take their word for it, you talk to them under oath and get valuable information.
If we've done our job in the discovery phase, an employer will look at summary judgment and look at its odds in summary judgment and say, we're not going to win this. In other words, confront the reality that they're going to be defending a jury trial if they don't settle with us. And so, frankly, the majority of the time, we're able to get an employer to settle with us even before the summary judgment briefing has been completed, because essentially the writing was on the wall.